should you take your employer to court? It's a question I actually come across fairly frequently, a bit more frequently than I would like. There has been a rise, I believe, in the last few years in legal action between employers and employees. And we are increasingly seeing that, the limits are being pushed, and, it's going through to either a Fair Work tribunal hearing, or it's going into some form of, civil litigation to try and resolve matters. Overall, my general advice is to try and avoid legal action with an employer. There's a number of key reasons for this. First and foremost, it can be incredibly draining, distracting, destructive. It can take many, many months and years of your life. And in certain circumstances, it can be extremely costly. And there's no real guarantees on the outcome. Over the years, having seen various legal matters take place and being involved in my own litigation over many years in business, you're never 100% sure how things are going to play out in a courtroom setting, and so you really want to avoid this at all costs. And I think people, can often get very committed to an action, but haven't fully thought through the consequences, and they assume that they're going to win. Court costs and legal costs can be extremely, expensive, and they mount up very, very quickly. So you have to be very, very cautious. Secondly, it can have a very big impact on your future employability. If you have taken an employer to court, these things then become a very public matter, and the outcomes are very transparent in terms of orders that might be made. So it can have a negative impact even if you win. So there is definitely a prejudice against employees who take employers to court. So you have to be very, very mindful of reputational issues. Wherever possible, though, I don't recommend you just fold and walk away and accept whatever has come your way. You are certainly within your rights to stand up for yourself, to stand up for your employment contract, and if something has been done wrong, to seek some form of remedy. But there's a lot of techniques that you can use that can enable you to get to a very good outcome without having to go to court. So what I recommend is when something has arisen, say, for example, an employer is trying to terminate your employment or move you on, so to speak, you may have to stand your ground, and I would definitely advise you as early as possible to get legal advice. So I would definitely get legal advice and get them to help you draft your communications to your employer, setting things out clearly. So a good employment lawyer will give you, the lie of the land, where things are at, what your case might look like, where some of your weaknesses might sit, and some of the things you want to try and work towards in a conciliatory way to try and get a good outcome. In the early days, when you're negotiating with an employer to try and achieve an outcome, it's often very helpful not to have legal letterhead involved. But it doesn't mean you can't get the advice and get the lawyers to help you draft the email, for example, to the HR department. The HR department will immediately recognise that you've got advice because they'll see the tone or the language that you're using, and that puts them on notice that, someone's maybe looking at this matter external to the organisation. We can't necessarily get away with what we thought we were going to get away with. This is maybe going to potentially go legal. So maybe we better just sort of try and sort this out. So, even something as subtle as just getting advice to help you draft your initial communications can be very helpful. And we had this happen just recently with a major IT company. This individual was being made redundant, but they didn't want to pay out a redundancy package effectively. And so they were basically sort of trying to put the person into a position that was not suitable, very vastly junior to the position he had held before, and saying, well, look, you're going to have to take a pay cut in this new role, and we would prefer not to pay you out for 25 plus years of service on a redundancy payout. And so there was this complex kind of negotiation going on. And so we got legal advice, and the letters kept going to the HR department. When will this be resolved? When will you take care of this? And there were certain words that we used in the email communication that put the HR department on notice, and a redundancy package was eventually negotiated successfully, and it was a good outcome for that individual employee. Sometimes then you need to go the next step, and you're still in a dispute and you can't reach an agreement with your own efforts. Then you might put things onto letterhead, and what you want to try and do then is try and bring it to a satisfactory conclusion. Again, you haven't had to go to court. You've spent some money on some legal letters. That probably cost you a few $100s each time. They go back and forth, but you haven't spent the big money on preparing a case, a statement of claim, hiring a barrister. You're into tens of thousands very quickly once you start going to a courtroom setting. So just consider that. So certainly don't roll over, take things that are not correct, stand up for your rights, but get good advice and tread carefully and try wherever possible to solve things with an employer rather than go the full Monty down a courtroom pathway. Generally speaking, it only works out in a very small number of circumstances. Usually there's quite a high price to be paid.